ICE, identification and proof of legal status.
I'm a licensed attorney. My ID is in the car. Am I being detained because I'm a licensed Texas attorney and I know my rights?
That's not what I asked you.
Immigration and Customs Enforcement. The agents identified themselves and demanded identification and proof of legal status immediately. The woman loading groceries into the rental car straightened, movements deliberate, hands visible. Her voice carried across the parking lot, calm, professional, the tone of someone accustomed to hostile rooms. She informed them she was a Texas State Bar member, a licensed attorney named Donna Pearson, and that her identification was in the vehicle. The lead agent's face remained stone. His partners were already spreading wider, boxing her in. He'd made his assessment before approaching. He insisted on documentation proving citizenship. Now, the Fresh Mart on Lindell Avenue was midway through its Saturday rush when federal authority arrived unannounced. 10:47 a.m. Minnesota spring. The kind that promised warmth but delivered crisp air and sunlight that turned shopping cart chrome into scattered mirrors across black asphalt. Donna Pearson had pulled into the lot 20 minutes earlier for a routine stop before driving to her mother's house. Weekend casual, light jacket, fitted jeans, her professional life packed away for 2 days. Her 8-year-old son had been negotiating lunch options since they left the hotel. Her 6-year-old daughter had already claimed an apple from the shopping bag, juice running down her chin as she leaned against the car's rear quarter panel. Just another errand. Except 3 ICE agents were stepping out of an unmarked SUV positioned with clear sight lines across 4 parking rows. Their body cameras were already recording what would become the most expensive grocery trip in Minnesota history. If you're ready to watch institutional racism get dismantled one verdict at a time, hit that like button right now. Drop a comment telling me where you're watching from, because choosing to engage with this story is choosing the side of justice over abuse of power. Subscribe and turn on notifications so you don't miss tomorrow's story of authority figures messing with the wrong person and paying for it. Let me know in the comments if this story hits different. Agent Dwight Palmer led the approach. His partners, Agents Kowalski and Briggs, moved in tactical spread, the kind of formation designed for suspects who might run or resist. Donna tracked them through her peripheral vision as she set a bag of vegetables into the trunk. 15 years of practicing law had trained her to read rooms, to catalog body language, to assess threat levels in seconds. Federal agents. Ice patches visible on tactical vests. Hands positioned for quick weapon access. Moving toward her rental car like the conclusion had already been written. She closed the trunk slowly. Kept her hands where they could see them. The Fresh Mart parking lot sprawled around them. Saturday shoppers pushing carts, car doors slamming, the distant beep of the crosswalk signal. Sunlight glinted off windshields and shopping cart handles. Her daughter had stopped mid-bite of her apple, sensing the shift in her mother's posture. Her son went quiet, his 8-year-old instincts recognizing danger even if he couldn't name it. Palmer stopped 6 feet away. Professional distance. His partners angled to cut off potential exit routes. One toward the driver's door, one blocking the gap between her car and the adjacent minivan. The demand came flat, procedural, the words practiced from repetition. He required identification, proof of legal status, and immediate compliance. Donna kept her voice even, projecting across the space between them. She stated clearly that she was a licensed attorney with the Texas State Bar, that her name was Donna Pearson, and that her identification was in the vehicle. She gestured slowly toward the driver's seat, telegraphing every movement. Palmer's expression didn't shift. His tone carried the weight of someone accustomed to excuses, to people claiming credentials they didn't possess. He told her that everyone claimed something. He needed documentation proving citizenship right now, not licenses, not professional credentials, but proof of legal presence in the United States. The skepticism in his voice ignited something cold and controlled in Donna's chest. Not panic. She'd been underestimated before, had her authority questioned in boardrooms and courtrooms by men who made assumptions before she spoke. This was different only in uniform. She reached for the driver's door handle. Slow. Deliberate. Announcing her movements like she was defusing ordnance. She recited her bar number aloud, clear enough for any recording devices to capture. She stated her law firm in Houston and the federal courts where she held admission. Kowalski moved closer, peering through the car's rear window. Briggs shifted to block the space behind her. The tactical formation tightened. Palmer stepped forward. His hand moved toward her wrist before she could retrieve her wallet from the center console. Physical contact. Firm grip. Professional restraint techniques. Donna's son started forward, 8 years old and already understanding that men were putting hands on his mother. A store employee in a Fresh Mart vest had stopped pushing carts, phone already out, recording. Other shoppers slowed, attention drawn by the federal presence, by the black woman being detained in broad daylight while her children watched. The handcuffs came out smooth, practiced. Standard issue restraints, the metal cold against Dona's wrists as Palmer secured them behind her back. She kept reciting her credentials, bar number, firm name, federal court admissions, projecting every word for the camera she could see pointed their way from 3 different angles. Her daughter dropped the apple. It rolled under the car, forgotten. Both children were crying now, the 6-year-old's wail cutting across the parking lot. Her son was shouting questions. Where were they taking her? What was happening? Why wouldn't they listen? A Fresh Mart employee, young woman, maybe 20, name tag reading Jessica, rushed over, hands out in the universal gesture of trying to calm frightened children. She was speaking softly, asking if they were okay, if she could help, her own phone out and recording the federal agents separating a mother from her kids in a grocery store parking lot. Dona was moved toward the unmarked SUV. Her groceries remained scattered across the trunk, bags of produce, cartons of juice, the makings of tomorrow's lunch at her mother's house. Her rental car sat unlocked, keys still in her jacket pocket, now inaccessible behind her back. Palmer guided her into the SUV's rear seat. Kowalski and Briggs followed, the doors closing with the heavy thunk of government vehicles built for prisoner transport. Through the tinted window, Dona watched her children clinging to the Fresh Mart employee, both crying, neither understanding why federal agents had just arrested their mother for loading groceries. Her mind was already working. Cataloging. Building the case that would define her next 6 months. Unlawful seizure without probable cause. Detention without reasonable suspicion. Separation of minor children from their legal guardian without emergency justification. Dismissal of clearly stated professional credentials. Racial profiling, because Palmer had looked at her and seen someone who didn't belong, who needed to prove citizenship while loading organic vegetables into a rental car in a Minnesota suburb. The SUV pulled out of the lot. Through the rear window she could see the crowd gathering, phones raised, recording everything. The front seat conversation started 3 minutes into the drive. Palmer and Kowalski began discussing the day's numbers. Casual. The tone of colleagues comparing productivity metrics. They noted they'd made quota for the week, 15 detentions across 3 days. Palmer mentioned the district supervisor would be satisfied. Kowalski referenced the new targeting protocols, explaining how they were focusing on minority neighborhoods and high-traffic areas where they could pull easy numbers without extensive surveillance investment. Palmer agreed. He said efficiency mattered, that resources were limited, and that going where the numbers were made sense from a management perspective. Dona committed every word to memory. The phrasing. The casual acknowledgement of quota systems. The explicit strategy of targeting minority communities for detention metrics. They weren't even trying to hide it. She was just another number to them. Another body to process. Another check mark on the weekly report that would justify next quarter's budget allocation. The processing facility was 40 minutes north, a squat government building with reinforced glass and parking lots surrounded by chain link. They brought her through a side entrance, away from public view, into fluorescent-lit corridors that smelled of industrial cleaner and stale coffee. The processing was mechanical. Paperwork. Photographs. Fingerprints that went into federal databases despite her repeated assertions that her credentials were easily verifiable through the Texas State Bar website. Palmer logged her personal effects: wallet, phone, keys, jacket. She requested verification of her bar membership. She requested a phone call to her attorney. She requested contact with the Texas Bar Association. All requests were noted. None were immediately actioned. They placed her in a holding cell, 8 by 10 feet, concrete bench bolted to the wall, toilet in the corner, fluorescent panels humming overhead with a particular frequency that induced headaches after prolonged exposure. The door closed. Locked. She was alone. Dona sat on the concrete bench and began the mental documentation that would become the foundation of her lawsuit. 10:47 a.m., initial contact in Fresh Mart parking lot. 3 agents, tactical approach, no warrant presented. 10:52 a.m. handcuffs applied despite compliance and stated credentials. 10:55 a.m. separation from minor children, ages 6 and 8, transferred to civilian employee care. 11:03 a.m. overheard conversation regarding quota fulfillment through minority neighborhood targeting. 3 hours. That's how long they kept her. 3 hours under humming fluorescent lights, reviewing the trajectory that had brought her here. Law school at Howard University, top 10% of her class. Federal clerkship that opened doors across the South. 15 years building a civil rights practice in Houston, handling cases of employment discrimination, housing violations, wrongful termination based on protected characteristics. She'd spent her career documenting how assumptions based on skin color overrode credentials, how bias operated in systems designed to appear neutral. She'd written briefs on disparate impact, on the subtle mechanisms of institutional racism that people denied existed because the discrimination wasn't explicit, wasn't announced, was just the accumulated weight of 1,000 small decisions that happened to fall hardest on Black and brown communities. And now she was living it. Handcuffed in a Fresh Mart parking lot. Separated from her children. Detained without cause beyond the fact that Agent Palmer had looked at her and decided she needed to prove she belonged. Her children. 6 and 8 years old. They'd watched federal agents put their mother in handcuffs. They'd been left with a stranger while she was driven away in an unmarked vehicle. They were probably terrified. Probably crying. Probably wondering if she was coming back. The trauma calculus was already forming. The nightmares that would follow. The anxiety that would manifest when uniformed authority appeared in their peripheral vision. The questions about safety and fairness and whether their mother could actually protect them from people with badges and guns. Her mother would have picked them up by now. Driven them to her house in South Minneapolis. Her mother, who'd grown up in Texas during segregation, who taught Donna that survival meant documentation, meant knowing your rights, meant never giving them an excuse to make the violation easy. Her mother would tell her to fight back. To not let them bury this. The cell door opened at 2:14 p.m. Palmer stood in the hallway, paperwork in hand. He informed her that her credentials had been verified. The Texas State Bar had confirmed active membership. Federal court records showed admission in 3 districts. She was free to go. No apology. No acknowledgement of the 3-hour detention. No explanation for why verification had taken longer than the 30 minutes required to access public databases. Just the return of her personal effects and directions to the exit where she could arrange transportation. Donna walked out into afternoon sunlight, still wearing the same clothes from that morning's grocery run, her hands still bearing the red marks from 3 hours of handcuff pressure. Her phone had 63 notifications. Messages from her mother. Calls from colleagues. Links to social media posts showing her detention from multiple angles, already viral, already generating outrage and commentary and hashtags about racial profiling in suburban Minnesota. She stood in the parking lot and called her mother. The case was already building itself. She just needed to document everything before the memory faded, before the sharp edges of violation dulled into general grievance. She had 3 hours of detention to account for. She had the overheard quota conversation. She had multiple video recordings from civilian witnesses. She had her own professional credibility and 15 years of civil rights practice. And she had 2 traumatized children who would never look at federal authority the same way again. That was the part that transformed violation into purpose. The part that meant this couldn't end with her walking away, with filing a complaint that would disappear into bureaucratic review processes designed to protect institutional authority. This was going to trial. The reunion happened in her mother's living room 40 minutes after release. Donna walked through the front door and both children launched themselves at her before she'd cleared the threshold. Arms around her waist, her neck, faces buried against her jacket. The 6-year-old was hiccuping through tears she'd been holding back for hours. The 8-year-old gripped her sleeve like she might disappear again if he let go. Donna's composure, the professional calm that had carried her through handcuffs and detention and fluorescent lip processing, cracked. Not completely. Just enough for her children to feel her arms tighten around them, to hear the catch in her breath when she promised she wasn't going anywhere. Her mother stood in the kitchen doorway. 72 years old, hair silver, posture straight as rebar. She'd raised Donna in Houston during the 70s and 80s, had taught her daughter that dignity under pressure was inherited, that surviving discrimination required documentation and refusal to accept violation as inevitable. She didn't say anything immediately. Just watched her daughter hold her grandchildren, watched the trembling in small shoulders start to ease, watched Donna's professional mask reassemble itself piece by careful piece. When the children finally released their grip, when they'd been settled in front of the television with hot chocolate and the false comfort of cartoon normalcy, Donna's mother sat across from her at the kitchen table. She asked if Donna was going to let this go. The question wasn't really a question. It was a reminder of lineage, of the generations who'd fought back when fighting back carried consequences far worse than legal fees and public scrutiny. Donna shook her head. Not a chance. That night, after her children finally fell asleep, both in her bed, neither willing to sleep alone, Donna opened her laptop at her mother's dining room table and began the documentation that would transform violation into litigation. She started with timestamps. 10:47 a.m. Initial contact. 10:52 a.m. Handcuffs applied. 10:55 a.m. Children separated. Every minute accounted for, cross-referenced against her phone's GPS data and the timestamps on social media videos already circulating online. Badge numbers, she'd memorized them during processing. Agent Dwight Palmer, badge 47832. Agent Kowalski, badge 51204. Agent Briggs, badge 48916. She pulled their names through federal employment databases, found their assignment history, their previous jurisdictions. The overheard conversation, she transcribed it word for word while the memory was fresh. The casual discussion of quotas. The explicit mention of targeting minority neighborhoods for easy numbers. The acknowledgement that efficiency meant going where detention metrics could be maximized with minimal investigative investment. She downloaded every video she could find. Bystander footage from 4 different angles showing her handcuffing, her children's distress, the tactical formation that had boxed her in before any conversation occurred. Body camera footage would come later through discovery, but civilian recordings established the baseline narrative that federal authorities would have difficulty contradicting. Her children woke twice that night. Nightmares. The 6-year-old asking if the men were coming back. The 8-year-old wanting to know if his mother had done something wrong, if that's why they'd taken her. Donna held them. Reassured them. Made promises about safety she wasn't entirely certain she could keep. By dawn she had 40 pages of notes. Documented timeline. Witness identifications. Constitutional violations cataloged by category. 4th Amendment unlawful seizure, 14th Amendment equal protection breach, 5th Amendment due process denial. The framework of a federal civil rights lawsuit taking shape in structured legal language. The flight back to Houston departed at noon. Her children stayed close through security, through boarding, through the 2-hour flight where they both chose the middle seat so they could maintain physical contact with her. Monday morning, Donna walked into the downtown offices of James Rutherford. 68 years old, legendary civil rights attorney, the kind of legal mind that had dismantled discriminatory systems across 3 decades of practice. They'd worked together on employment discrimination cases. He knew her reputation, knew her precision. She spread her documentation across his conference table. Explained the parking lot detention. Played the videos. Showed him the transcribed quota conversation. Rutherford listened without interrupting. Reviewed the evidence with the methodical attention of someone who'd built careers on finding the flaws in institutional authority. When she finished, he sat back and considered the ceiling for 30 seconds. He told her this wasn't just her case, it was systemic. She had evidence of quota-driven enforcement targeting minority communities. That wasn't a single bad decision, he explained, that was policy. That was discoverable through their internal communications, their performance metrics, their district supervisor directives. He pulled a legal pad across the table and started outlining causes of action. 4th Amendment violations. Unlawful seizure without probable cause or reasonable suspicion. 14th Amendment equal protection breach. Racial profiling as operational strategy. Emotional distress, both hers and her children's documented trauma. And the new angle, systemic corruption through quota enforcement mechanisms that incentivize detention regardless of legal justification. The government's first settlement offer arrived 3 weeks later. $75,000. Standard payout for documented federal overreach. Attached confidentiality agreement requiring she never discuss the incident publicly, never disparage ICE or its agents, never use the detention as basis for broader criticism of enforcement policies. Donna rejected it within 2 hours. The second offer came after preliminary discovery requests went out. $300,000. Same confidentiality requirements. Same demand for silence in exchange for compensation. Rejected. Discovery intensified. Document requests targeting IC email servers. Depositions scheduled for Palmer, Kowalski, and Briggs. Interrogatories about quota systems, performance metrics, targeting protocols. Media attention growing as civil rights organizations filed amicus briefs supporting her case, as news coverage highlighted the parking lot videos, as the narrative shifted from isolated incident to systemic investigation. The third offer arrived on a Friday afternoon. $1.2 million. The confidentiality clause had been softened but not eliminated. She could discuss the incident but not characterize it as representative of broader ICE practices. Rutherford brought the offer to her office personally. laid it on her desk and waited while she read through the terms. He said quietly that this was generational wealth. That it would pay for her kids' college, set up trust funds, provide security. Donna looked at the number. Looked at the restrictions. Looked at the photographs on her desk. Her children at the beach last summer, smiling, unaware that federal agents would soon traumatize them in a grocery store parking lot. She told him that if she took this, it would happen again. Different parking lot. Different attorney. Different kids watching their mother get handcuffed for being black in public. Rutherford nodded slowly. He acknowledged that he knew, and that was why he brought it in person instead of just declining over email. He'd wanted her to see what she was turning down. Donna told him to reject it. Discovery produced the evidence that transformed personal violation into systemic indictment. ICE internal emails discussing monthly detention targets. Spreadsheets tracking agent performance against quota metrics. District supervisor directives explicitly instructing field teams to focus on high minority neighborhoods because statistical analysis showed higher detention rates per contact hour. The quota system wasn't hidden. It was policy. Formalized through internal performance reviews that rewarded agents who maximized numbers, that created institutional pressure to detain first and verify later because processing errors could be corrected but quota shortfalls reflected poorly on performance evaluations. Donna sat in her office reviewing the discovery documents while her children attended their third therapy session. The therapist had given her copies of their intake assessments. Nightmares 3 to 4 times weekly. Anxiety around uniformed authority. Separation fears manifesting as clinginess and regression in independence. Her 6-year-old had drawn a picture during therapy, stick figures of a family, a car, and large figures in dark uniforms with hands reaching toward the mother figure. The child psychologist's notes indicated significant trauma response consistent with witnessing parental arrest. Do you believe federal agents need stricter guidelines to prevent such heartbreaking ordeals? Drop yes or no in the comments below and share why, or pass the story along to spread awareness. Donna closed the therapy file and returned to case preparation. The trial date was set for October, 6 months after the parking lot detention. 6 months to build the argument that would force institutional accountability. She started mentoring during the pretrial period. A law student from Houston, second-year, scholarship kid, first-generation college graduate from a community where interactions with federal authority rarely ended well. The student showed promise but lacked polish, needed someone to teach precision in legal argument, to demonstrate how cases were built from documented facts rather than emotional appeal. They met twice weekly. Reviewed case law. Practiced oral arguments. Donna showed her how to construct briefs that anticipated opposition, how to build evidentiary foundations that withstood cross-examination. Teaching helped. Gave structure to days otherwise consumed by deposition preparation and discovery review. Gave purpose beyond personal vindication. Her children's therapy continued. Progress was slow. Trauma didn't resolve on convenient timelines. But the nightmares decreased. The separation anxiety eased marginally. They could sleep in their own beds most nights, though they still checked frequently to confirm their mother was home, was safe, hadn't been taken again. Donna drew on 15 years of civil rights practice to prepare for trial. Reviewed her own case history, employment discrimination suits, housing violation litigation, wrongful termination defenses. She'd spent her career arguing that bias operated through systems designed to appear neutral, that discrimination could be measured through disparate impact even when explicit prejudice wasn't articulated. Now she was applying that expertise to her own case. Building the argument that Agent Palmer's decision to detain her hadn't been individual prejudice but systemic racism operationalized through quota enforcement policies that targeted minority communities because efficiency metrics rewarded high detention numbers over legal justification. The discovery evidence supported it. The emails and spreadsheets and supervisor directives created a paper trail showing institutional pressure to maximize detentions regardless of probable cause. Palmer hadn't been a rogue agent. He'd been following protocols designed to generate numbers. That made the case bigger. Made it matter beyond personal compensation. Made it the kind of litigation that could force policy reform if the verdict came back strong enough, public enough, expensive enough to create institutional incentive for change. October approached. Donna reviewed her testimony notes, her evidence exhibits, her witness preparation. Rutherford handled the legal strategy, but this was her case. Her violation. Her children's trauma. Her opportunity to transform a parking lot humiliation into precedent that might protect the next black attorney loading groceries while federal agents made assumptions. She was ready. Hennepin County Courthouse occupied a full city block in downtown Minneapolis, concrete and glass, federal architecture designed to communicate authority through geometric severity. The trial commenced on a Tuesday morning in October, 6 months after the Fresh Mart parking lot detention, autumn light slanting through courtroom windows onto polished wood and brass fixtures that reflected institutional permanence. The gallery was packed before proceedings began. Civil rights activists, media representatives with notebooks and recording devices, law students observing high-profile litigation, community members who'd watched the viral videos and wanted to witness accountability unfold in real time. The jury had been seated the previous week, 12 members diverse in age and background, selected through voir dire that had focused heavily on attitudes toward law enforcement, personal experiences with discrimination, capacity to evaluate evidence objectively despite emotional content. Donna entered at 8:55 a.m. navy suit, professional bearing, her mother and children seated in the second row but positioned to avoid direct courtroom camera angles. She'd shielded them from media coverage as much as possible, but they'd insisted on attending opening statements. Wanted to see their mother fight back. Wanted to watch the men who'd handcuffed her answer for it. Judge Patricia Thornton presided, 22 years on the federal bench, reputation for strict evidentiary standards and impatience with procedural games. She called the court to order at precisely 9 o'clock. Opening statements began with Rutherford presenting the prosecution narrative. He opened with synchronized footage, bystander video on the left screen, body camera feed on the right screen, both showing the same events from different angles. The parking lot. Saturday morning sunlight. Donna loading groceries. Her children visible, casual, unaware. Then the agents approaching. Tactical spread. The conversation inaudible on civilian footage but captured clearly on body cameras. The demand for identification, Donna's calm assertion of credentials, Palmer's dismissal. The handcuffs. The children's distress. The separation. Rutherford let the footage play without commentary. Let the jury watch a licensed attorney get detained in front of her crying children while she recited her bar number and federal court admissions to agents who'd already decided she needed to prove her right to exist in a Minnesota parking lot. When the footage ended, he outlined the case simply. Fourth Amendment violation, seizure without probable cause. 14th Amendment breach, racial profiling as enforcement strategy. Emotional distress, documented trauma in 2 minor children. And systemic corruption, quota-driven targeting of minority neighborhoods for detention metrics. The defense countered with the standard qualified immunity argument. The defense attorney explained that Agent Palmer had been acting in good faith, conducting routine enforcement checks within his authorized jurisdiction. Immigration status verification was legitimate law enforcement activity, he argued. If mistakes occurred, they were reasonable errors made under operational pressure, not constitutional violations requiring damages. The defense attorney characterized the detention as brief, professional, ultimately resolved through proper verification procedures. An unfortunate misunderstanding, perhaps, but not an actionable civil rights violation. Judge Thornton called the first witness at 10:15 a.m. Agent Dwight Palmer took the stand wearing his dress uniform. He testified to 17 years with ICE, multiple commendations, training in immigration law and enforcement procedures. He described the Fresh Mart operation as routine, observing the parking lot, identifying potential subjects for status verification based on behavioral indicators. Cross-examination began with Rutherford establishing baseline facts. He asked how long the parking lot observation had lasted. Palmer answered 12 minutes. Rutherford asked what behavioral indicators Palmer had observed that justified detention. Palmer responded that the subject appeared nervous, avoided eye contact, and matched demographic profiles consistent with enforcement priorities. Rutherford let that answer hang. Then he asked Palmer to clarify what demographic profile he meant. Palmer hedged, mentioning high-probability populations based on statistical data. Rutherford pressed, which statistics? Palmer cited regional data on undocumented populations. Rutherford continued, what specific behaviors indicated immigration violation? Palmer offered general indicators, body language, situational assessment. The cross-examination tightened. Palmer couldn't articulate specific suspicious behavior beyond Donna looking out of place. Couldn't explain why a woman loading groceries with children in a suburban parking lot represented sufficient probable cause for detention. Couldn't identify any intelligence or prior information suggesting she posed enforcement concern. What he could say, under direct questioning, was that his unit had detention quotas. That performance reviews evaluated agents partially on monthly numbers. That district supervisors distributed guidance on maximizing efficiency by focusing on areas with high minority populations because contact-to-detention conversion rates ran higher. The defense objected, arguing that qualified immunity protected good faith enforcement decisions and that Palmer had been following protocols. Judge Thornton allowed the testimony. She noted that protocols could be evaluated for constitutional compliance, and that quota systems could be examined as evidence of institutional pressure influencing individual decisions. Donna testified on day 3. Rutherford walked her through credentials, law degree, federal clerkship, 15-year civil rights practice, bar admissions across 3 states. Then through the parking lot detention minute by minute. She described the tactical approach. The dismissal of her stated credentials. The handcuffing despite compliance. The separation from her children. Her testimony remained controlled, factual, the professional distance of someone recounting evidence rather than personal trauma. Until Rutherford asked about her children. The composure cracked slightly. Not theatrically. Just the brief pause before she described her 6-year-old's nightmares, her 8-year-old's anxiety around uniformed authority, the therapy sessions addressing trauma from watching their mother detained without justification. The defense cross-examination focused on procedural compliance. The defense attorney asked if Palmer had identified himself clearly. Donna confirmed yes. Had he informed her she was being detained? Yes. Had he processed her according to standard protocols? Donna replied yes, if standard protocols included ignoring easily verifiable credentials for 3 hours. Donna entered her post-release notes into evidence. The 40 pages of documentation she'd compiled the night after detention. Timestamps, badge numbers, exact quotes, the overheard quota conversation transcribed while memory was fresh. The defense objected, claiming hearsay, unreliable recollection and documentation created after the fact with litigation in mind. Judge Thornton reviewed the notes. She allowed them as present-sense impression and recorded recollection exceptions, noting that Donna had documented immediately after release, and that details were corroborated by video evidence and later discovery materials. Mid-trial, Rutherford introduced evidence that shifted the entire scope. During discovery review, Donna's legal team had identified a parallel case. Same day as her detention, April 15th. Same IC unit. Different location, St. Paul, 30 minutes from the Fresh Mart parking lot. Professor Sofia Ramirez. Latina, 41 years old, tenured professor of linguistics at a local university. Detained during her morning walk to campus. Processed through the same facility as Donna. But Professor Ramirez's outcome had been different. A processing error, her documents flagged incorrectly in the system, her assertions of citizenship dismissed as fraudulent. She'd been transferred to deportation proceedings before verification could be completed. By the time the error was discovered, she'd already been removed to Mexico, a country she hadn't visited since childhood. Professor Ramirez was a U.S. citizen. Born in California. Had never lived outside the United States. The deportation had been reversed eventually. Weeks later, after legal intervention, after international coordination, after irreversible damage to her career and psychological well-being, Rutherford entered the Ramirez case file into evidence. He demonstrated that the same unit, operating under the same quota pressure, had detained and deported a citizen because processing efficiency trumped verification accuracy. The courtroom went silent. The defense team scrambled into urgent consultation. Judge Thornton called recess. When proceedings resumed, the defense filed emergency motions to suppress the Ramirez evidence as prejudicial and beyond the scope of Donna's individual case. Thornton denied the motion. She explained that the evidence demonstrated systemic practice, showed that Donna's detention wasn't an isolated incident but an operational pattern, and illustrated the actual stakes. That Donna had narrowly avoided deportation not through system safeguards but through her own legal knowledge and persistence. Expert witnesses testified over the next week. A child psychologist explained trauma response in minors who witnessed parental arrest, showing the jury drawings Donna's children had created during therapy. A constitutional law professor detailed Fourth Amendment protections, explaining how quota systems create institutional incentive for unlawful seizures. A statistical analyst presented data on detention rates across Minneapolis neighborhoods, clear disparities showing minority communities targeted at rates disproportionate to population or immigration violation intelligence. The defense's qualified immunity argument collapsed under the weight of evidence showing Palmer hadn't been making good faith enforcement decisions but following quota protocols that prioritized numbers over constitutional compliance. Closing arguments spanned 2 days. The defense pleaded for understanding enforcement complexities, the difficulty of making split-second decisions, the need for legal protection allowing agents to operate without fear of personal liability. Rutherford focused on what the evidence showed. He argued that Agent Palmer had looked at Donna Pearson and seen skin color, not credentials. That he detained her not because she exhibited suspicious behavior but because she fit demographic profiles useful for meeting monthly quotas. That he dismissed her stated bar membership because his training prioritized detention numbers over constitutional rights. And the system that had produced that decision, the quota pressure, the targeting protocols, the performance metrics rewarding efficiency over legality, remained operational unless verdict and damages made institutional reform necessary. The jury received instructions on Friday afternoon, deliberated through the weekend, through Monday, through Tuesday. 5 days of deliberation while Donna waited with controlled patience that barely masked the anxiety building with each additional hour. Her children stayed home from school, wanted to be present when the verdict came. Her mother remained steady, the same strength she'd embodied through decades of watching systems fail and occasionally, rarely, deliver accountability. Wednesday morning, the jury signaled readiness. Judge Thornton reconvened court at 10 a.m. The gallery was packed again. Same activists, same media, same community witnesses who'd invested emotional energy in watching justice play out through proper procedure rather than protest. The jury foreman stood. The foreman was a middle-aged accountant. Jury selection had identified him as deliberate, thorough, the kind of analytical mind that would examine evidence systematically rather than react emotionally. He stood holding the verdict form, judge waiting, gallery silent except for the ambient sound of breathing and shuffling feet. Judge Thornton asked the standard question. She inquired whether the jury had reached a unanimous verdict on all counts. The foreman confirmed they had. Unanimous on all counts. Count 1. Unlawful detention in violation of the Fourth Amendment. The foreman's voice carried across the courtroom without inflection, reading what 12 citizens had concluded after 5 days of deliberation. Guilty. The federal agents had seized Donna Pearson without probable cause, without reasonable suspicion, without constitutional justification. Count 2. Violation of equal protection under the 14th Amendment through racial profiling. Guilty. The detention had been based on demographic appearance rather than specific behavioral indicators, constituting discriminatory enforcement. Count 3. Emotional distress inflicted on Donna Pearson. Guilty. The evidence of therapy records, testimony, and documented trauma established actionable harm. Count 4. Emotional distress inflicted on her minor children through witnessing unlawful detention. Guilty. The child psychologist testimony and therapeutic documentation supported findings of significant psychological harm. The courtroom remained silent through the verdict reading, the weight of guilty repeated across 4 constitutional violations creating a cumulative impact that felt like pressure change before weather shift. Then came damages. The jury awarded $13 million. Compensatory damages for Donna's detention, legal fees, lost professional time, therapeutic costs for her children. Punitive damages designed to punish the quota system, to signal that detention metrics couldn't override constitutional protections, to make the institutional cost of racial profiling expensive enough to force policy reform. The gallery erupted. Not wild celebration, this was a federal courtroom, but sustained applause that Judge Thornton allowed for 15 seconds before restoring order. Donna sat motionless. Rutherford's hand on her shoulder. Her mother in the second row with tears tracking down her face. 72 years of watching discrimination operate through systems supposedly designed for justice, finally witnessing accountability delivered through those same systems. Her children didn't fully understand the number. 13 million existed outside their comprehension. What they understood was the applause, the verdict repeated 4 times, the fact that the judge and jury had agreed their mother had been wronged and the men who'd done it would face consequences. Agent Palmer's face held nothing. Professional blank. His partners equally expressionless. The defense team was already preparing appeal documentation. Judge Thornton dismissed the jury with thanks for their service. Set a hearing for 30 days out to address enforcement and compliance. Adjourned court at 11:42 a.m. Outside the courthouse, media congregated with cameras and microphones. Rutherford handled the statement. He outlined the verdict, emphasized systemic implications, noted that 13 million represented accountability for quota-driven enforcement that had violated Donna's rights and traumatized her children. Donna stood beside him without speaking. Let the verdict speak. Let the evidence and testimony and 5 days of jury deliberation communicate what needed to be said. Consequences manifested over the following weeks. Agent Palmer received suspension pending internal investigation. Kowalski and Briggs faced similar administrative action. The district supervisor who distributed the targeting protocols was reassigned. ICE headquarters announced policy review. They committed to examining quota systems, detention metrics, and performance evaluations that incentivized numbers over constitutional compliance. They promised bias training, revised protocols, and oversight mechanisms designed to prevent racial profiling. Federal committees opened investigations. Congressional hearings were scheduled. The Ramirez deportation case received renewed attention as evidence of systemic failure requiring legislative intervention. The verdict established precedent. Created case law that other civil rights attorneys could cite when challenging similar detentions. Demonstrated that qualified immunity didn't protect agents operating under institutional policies that violated constitutional protections. DONA used a portion of the settlement to establish Pearson and Associates, a civil rights law firm in Houston specializing in discrimination cases, wrongful detention litigation, systemic racism in government enforcement. The firm prioritized pro bono work for clients from marginalized communities who couldn't afford representation against federal authority. She hired diverse staff. Attorneys who understood systemic abuse through personal experience, not just academic study. Paralegals from communities where interactions with law enforcement created trauma rather than protection. The firm won its first case 6 months after founding. Employment discrimination suit against a Fortune 500 company with documented patterns of promoting white candidates over equally qualified minorities. Settlement included policy reform and diversity training mandated through court order. More cases followed. Housing discrimination. Wrongful termination. Police misconduct. Each victory built reputation, created precedent, forced institutional accountability through litigation that refused settlement offers containing confidentiality clauses. DONA established scholarship funds. Youth programs teaching legal rights and documentation strategies. Partnerships with law schools providing mentorship for students from backgrounds similar to hers. First generation, minority, navigating systems designed to benefit others. She lectured at universities. Turned the parking lot detention into case study on transforming violation into vindication. Taught law students that precision in documentation, refusal to accept quiet settlement, commitment to public accountability, those were the tools that dismantled systemic racism one verdict at a time. Her children grew. The trauma didn't disappear. Trauma rarely did, but they learned to articulate it. Understood what had happened to them. Channeled the experience into advocacy. Her daughter, at 16, testified before a state legislative committee considering police reform. She described watching her mother handcuffed, explained how that memory shaped her understanding of institutional authority and the need for accountability mechanisms. Her son at 18 chose law school. He wanted to continue the work his mother had started. Wanted to represent people who got detained in parking lots for existing while minority. Years accumulated. The firm expanded. Pearson and Associates opened satellite offices in Dallas, San Antonio, Austin. Hired more attorneys, handled more cases, won more verdicts that forced policy changes and established precedent. The Fresh Mart on Lindell Avenue remained operational. The parking lot unchanged except for the occasional visitor who recognized the location from viral video, from news coverage, from the case that had transformed a routine grocery stop into $13 million in damages and institutional policy reform. DONA returned occasionally. Not dwelling on trauma but acknowledging transformation. She'd stood in that parking lot loading groceries while her daughter ate an apple and her son negotiated lunch plans. She'd been handcuffed, detained, separated from her children because Agent Palmer had looked at her and decided she needed to prove citizenship. And she'd refused to let that violation remain quiet. Had documented everything. Had rejected settlement offers that would have silenced her. Had taken the case to trial and forced a jury to evaluate whether quota-driven enforcement targeting minority communities violated constitutional protections. The verdict had been unanimous. $13 million. Policy reforms. Precedent for future cases. A law firm dedicated to continuing the fight. The narrative closed not with triumph but with recognition. Systems changed slowly. Discrimination adapted when forced to. Racism found new methods when old ones became legally untenable. But accountability mattered. Verdicts mattered. Forcing institutions to pay consequences for violations mattered because money drove policy when justice alone didn't. Donna Pearson had turned a parking lot humiliation into legacy, had transformed personal trauma into structural change, had proven that underestimated resilience, the kind built through generations of surviving systems designed to diminish, could dismantle corruption when supported by documentation, legal precision, and absolute refusal to accept settlement over truth. The grocery run had cost the federal government $13 million. But the real cost was the precedent, the reformed policies, the law firm that would fight similar battles for decades, the scholarship recipients who would become attorneys, the children who would grow into advocates carrying forward the understanding that injustice documented became injustice actionable. That was the legacy. That was what made the parking lot detention on a spring Saturday morning transform from violation into vindication. And that was what ensured the next Agent Palmer would think twice before handcuffing a black attorney loading groceries while her children watched. Because now there was precedent. There was verdict. There was 13 million reasons to follow constitutional protections instead of quota metrics. And there was Pearson and Associates, ready to litigate the next case when prevention inevitably failed. Justice as method, not spectacle. Truth as endurance. Power underestimated, then proven unstoppable. If this story of justice prevailing over institutional racism resonated with you, make sure you hit that subscribe button and turn on notifications, because tomorrow we're bringing you another story of people in power messing with the wrong person and paying the price. And here's the question I want you to answer in the comments. Where are you watching from? Drop your location below and let me know if this story hits different for you. Your engagement isn't just a comment, it's choosing the side of accountability over abuse of power. Share this video to spread awareness. Let's make sure stories like Donna's reach everyone who needs to hear them. I'll see you in the next one.